appellee in this matter made a great deal out of Mr. Vegas's license plate, Slick, and the general character of Mr. Vegas. This is precisely the sort of vague undesirability that characterized the defendants in Papa Christou, and I'm glad that they brought up the arbitrary law enforcement context, because that is an issue here. It's an important issue in connection with the vagueness argument. This statute lends itself to arbitrary law enforcement.
Is there any evidence in the record that that was occurred in this case or any other case?
No, Your Honor, there is not.
Well, then how is it material?
It is material, Your Honor, because Mr. Vegas must show either that the statute provides inadequate notice, which I think he's demonstrated in this case, or that there is arbitrary law enforcement. While either of these is sufficient, Your Honor, I'm simply saying...
I understand that he has to show one of those two, but you're suggesting that maybe this would be used arbitrarily in the past or could in the future, or could be used arbitrarily in the future, not that it has been used arbitrarily in this case or any other case that we know about.
Your Honor, the state would have Mr. Vegas put in a catch-22, that he must show arbitrary enforcement or encouragement of arbitrary enforcement on the one hand, yet that he cannot point to hypothetical applications of the statute in order to do so. Now, in Papa Christou versus City of Jacksonville, Florida, Justice Douglas treated a similar catch-22. And in his analysis, he looked at things like the vague undesirability of the people who had been prosecuted under the statute. He also looked at the fact that the statute made criminal activities which by normal standards, modern standards, are innocent. That is what's going on here. Kansas has recognized that video poker machines are legal. Now, that to me is some indication.
Kansas has recognized that video poker machines.
Absolutely.
Well, but Kansas's recognition isn't an issue here. It's Texas, right? Texas hasn't so recognized.
That's true, Your Honor. I'm simply arguing that these sorts of machines are, by modern standards, innocent. And again, that returns us to the Papa Christou. Your Honor, the question is not whether gambling in general is innocent. The question is whether these machines are, in fact, innocent. And I would argue that they are, and that Kansas's recognition of that.
Opposing counsel said that under any of the instructions offered by various attorneys or by the parties here regarding the statute, that your client, that video poker is a gambling device. And if that's the case, then we're not worried about arbitrary enforcement, are we?
Your Honor, that is simply not the case. The only interpretation of the statute under which my client could possibly be guilty is an interpretation requiring only a mere chance, a speck of chance. Now, it's simply...
Isn't that contrary to the plain language of the statute, determined by chance? Isn't that words mean something different than a speck of chance or mere chance?
Your Honor, I would argue that determined by chance does indeed mean something more than a speck of chance or mere chance. However, the state...
And trial, didn't the fact finder decide that video poker was determined by chance?
They did, Your Honor. But that really sort of begs the question here, because we're trying to decide whether or not the fact finder had a clear enough statute in order to reach that determination. May I briefly conclude? They did not have a clear enough statute to reach that determination, and for that reason, the judgment of the Elsa Court of Appeals must be reversed, and Mr. Vegas's conviction must be vacated.
Thank you. This court is adjourned until further call.